is an appeal in the matter of Bratt versus Jones.
Morning, Mr. Rosenthal.
Morning, my lord. I appear on behalf of the appellant. Mr. Chapman and Mr. Allen appear on behalf of the respondents. May I just check that your lordships have all received a core bundle, a supplemental bundle, and an authorities bundle?
Yes, that's all we have. We think that maybe there's a few cases missing from your authorities bundle. Do you think that maybe Goldstein, Dennard, what was the other one we were talking about? Merivale's in there.
Yes.
Yeah, there's also one about there's the Suez case, the Suez, which is Brandon, called Brandon.
Anyway, there we are. We'll come to that.
Indeed, we will. My lord, I think that the parties were trying to keep to the recommended 10 cases in the authorities bundle, but I note what your lordship
But
said.
if you're saying,
Dennard is a decision of my lords.
Indeed.
but if you're saying that the whole thing's wrong, we've all got it wrong, then you do need to show the judge you say is wrong that he's wrong.
Indeed. I recognise that, my lord. Your lordship would have seen that permission to appeal was granted on 4 grounds. I propose to start with ground 1 and take them consecutively. I only make that point because there is a suggestion from the respondent that it isn't necessary to address ground 1 because the appeal ought to fail on the other grounds. But subject to your lordships, I propose to start at the top with the law and the issue raised by ground 1. In essence, the issue between the parties under ground 1 concerns the relevance of what's called the bracket or the range. And the question of whether the bracket is in the nature of a defence which a valuer can rely on to show that the valuer is not liable in respect of a valuation which might otherwise have been considered negligent because of mistakes in the process, and that is the respondent's case. Or, on the other hand, whether the bracket determines liability so that a claimant has to satisfy the court that a valuation falls outside of a bracket of reasonable valuations to prove negligence, or at least to create a presumption of liability where the evidential burden shifts to the valuer to prove that he wasn't negligent. So that they are the respective
Or if
positions.
you need to prove loss, if a claimant needs to prove loss, does the bracket operate to demonstrate that actually you suffer no loss?
It could operate in that way as well, my lord, yes.
That's an alternative. That's a third possibility.
It could be. I understand where your lordship's coming from on that.
I mean, these cases don't come up that often, do they? And the reason I started by saying there are some other cases is that it seems to me if you are saying to us that the way the judge approached it was wrong as a matter of law, then in this court we're going to have to say what would have been the right approach as a matter of law, and nobody's done that since Lord Justice Buxton.
Indeed. And we say that it is Merivale that sets the precedent in respect of the course that we say the court ought to have taken and ought to take in future cases. Before I open up the authorities bundle, I should just clear up one point, which is that we are not saying on this side that somehow Bolam doesn't apply to a negligence claim against a valuer. That the question really is how Bolam is applied in this context. We don't get the answer to that question from Bolam itself, that the test is well embedded in the law. Rather, the bracket approach, the way I've outlined it, is the way that the courts have developed for applying the Bolam test to a valuation which is alleged to have been produced negligently. In other words, the court determines whether the valuer has acted as a reasonably competent valuer ought to have acted by looking at the result or the product of the valuation rather than the reasoning that lies behind it. So what I propose to do, my lords, is to go first to the authorities to show how this has developed.
Is there a difference between types of valuation?
Well, the bracket test, as we'll see from Lord Justice Buxton in Merivale, applies where what is impugned is, as he put it, the figure. That's not quite what your lordship asked me. So there may be other allegations in respect of the valuer's performance of his task. But in terms of the types of valuation, we say that the bracket test applies whenever a valuation is impugned because of the figure that was reached.
Well, the point I was asking really is that in property valuations, there's something called the Red Book, right? Which I'm sure you're familiar with, which chartered surveyors use when valuing property. In businesses, it's rather different. There's no Red Book, as far as I'm aware, for valuing a business. And there are two types of valuation valuers might be asked to do. One where you give reasons and one where you give a figure. And again, is there a difference?
We say not, based on the authorities and the reasoning in the authorities. And the rationale for that is that what matters in a valuation is the figure.
And does it matter whether you're asked to value as an expert or in some other capacity?
Again, we say not, my lord. There are cases, so far as I'm aware, in which the question was raised as to whether an expert or a valuer appointed as an expert in the way that the defendant in this case was, is subject to the same duties as any other valuer instructed to value land. And the upshot of those cases is that the same duties do apply.
Is that entirely right? I mean, it's a point you just float through your skeleton. I mean, if you have somebody acting as an arbitrator, one of the things you might assume that they are obliged to do is to hear submissions from both sides. If they're acting as an expert, I think it's the case, you probably accept that they don't. And in this case, because the respondent was acting as an expert, it's not a ground of complaint that he didn't in fact come back to either side when he chose the comparable, which had arisen after the relevant date.
It's not a ground of complaint in the sense that that in itself would not be an issue that would cause him to have acted in breach of his duty.
But there's a difference between, in terms of the scope of a duty, for example, between an expert and an arbitrator.
Absolutely. Arbitrators are in a very different position. Arbitrators exercise a quasi-judicial role in accordance with the requirements of the Arbitration Act. So I accept entirely that arbitrators are different, but as between contractually appointed experts and valuers appointed to produce a valuation for other purposes, we say that the same principles apply.
Okay.
So, as I indicated, the main peg on which we hang the argument under ground one is Merivale. But before I take your lordship lordships to that. I propose to start with the legal and general case, which is behind tab 1 in the authority bundle.
So Maryvale was not mentioned by the judge, right?
It was mentioned by the judge. I'll come. The judge cited from Lord Justice Buxton's judgment that it was, we would say, rather selective citation. But I'll
Yes.
come on to what the judge did.
Yeah, sorry, I spelt it wrong. Yeah, paragraph 38. Yep.
So the precursor to Maryvale, as it were, is the legal and general case behind tab 1. This factually was a rather more straightforward case. It was a lender's claim in respect of a loan secured against a dwelling house, and the claimant in this case claimed that the defendant's mortgage valuation was negligent, in that the property had been overvalued. And the relevant discussion by the judge in this case begins. I'm going to use, unless your lordships prefer me not to, the PDF numbers at the bottom of the page in the authorities bundle.
Yep.
Page 6 in the bundle. Under the heading basis of liability, and picking up on the very last line, the judge set out some passages from the decision of Mr. Justice Watkins in Singer and Freelander. And then on page 7 at letter F, he turned to the contentions raised by the parties respective counsel. And the plaintiff in that case was arguing that a plaintiff can succeed in one of two ways, either by establishing that the defendant's valuation is outside of a bracket which a competent valuer could have valued the property at, described here as the result route, or alternatively that the plaintiff could succeed if he could show that the valuer had failed to exercise skill and care in the process of valuing, albeit that the final figure is within the bracket. So that was the plaintiff's contention. The defendant's contention, in the final paragraph, was that a plaintiff has to prove both of two things. First of all, that the figure was outside of, sufficiently as it's put, outside of the bracket to be regarded as negligent, and that the approach to the task was negligent. And as it's put in the last two lines by this judge, in other words, on that contention, the wrong result has to be reached by the wrong method. And then over the page on page 8, that the judge said that he wasn't satisfied that, at any rate, in a case of this kind, either formulation of the law is correct. So he began with a critique of the plaintiff's position. I don't propose to go through that, because what is more relevant for present purposes is what he said about the defendant's formulation on page 9. First of all, at letter C, the judge took issue with, picking up at the end of the second line, the proposition that liability can attach only when the value produced is sufficiently outside the acceptable bracket to be castigated as negligent, and he disagreed with that. He said the point of the bracket is that it demarcates the area within which careful valuers may reasonably differ. And the plaintiff doesn't have to show that the valuation which is under attack lay any particular distance beyond the bracket. And then the second issue that the judge had with the defendant's formulation is to do with the second thing that the defendant said a plaintiff has to prove. So, picking up in the second line, the paragraph beginning my second quarrel, In other words, I do not accept that where the figure under attack has been shown to be outside the acceptable bracket, the wrong result, a plaintiff has the additional burden of showing why the valuer reached that result, brackets the wrong method. And then dropping down to the final paragraph, I return to Singer and Freelander. Many, perhaps most valuation cases can be approached on the bracket basis. Pinpoint accuracy, as Mr. Justice Tasker-Watkins put it, is not to be expected. As soon as it is shown that the impugned valuation falls outside the bracket, and again I quote from Mr. Justice Watkins, the competence of the valuer and the sort of care he gave to the task are brought into question. Put another way, the plaintiff will, by that stage, have discharged an evidential burden. It will be for the defendant to show that, notwithstanding that the valuation is outside the range within which careful and competent valuers may reasonably differ, he nonetheless exercised the degree of care and skill which was appropriate in the circumstances. And then, finally, over the page on page 10, in the second paragraph, the defendant's formulation seems to me to erect a correspondingly unjust barrier in the path of a plaintiff for whom it must surely be sufficient to establish at any rate as prima facie evidence of negligence the fact of error without having additionally to identify the underlying methodological fault. Again, the suggestion that the plaintiff must show a valuation some way outside the bracket appears to me to subvert the whole point of proceeding on a basis which is itself favourable to defendants, that there is such a thing as an acceptable bracket. So,
does that mean the burden of proof shifts?
We say yes, and that in my submission is clearly what this judge was saying.
Which burden?
The evidential burden.
Right, because that's not really a burden at all. The legal burden doesn't shift at all, does
No.
it?
Well, that was my question. The burden of proof doesn't shift. Well, what's your case on that?
Well, we adopt the way it is described by Judge Langan in this judgment, and we say that follows through into Merivale. It is the evidential burden that shifts. A plaintiff, a claimant, satisfies the court that a valuation is outside of the bracket, and there is then a rebuttable presumption or a shifting of the evidential burden. It's put in both ways in the authorities, as we'll see, and it is for the defendant to show that, notwithstanding that the bottom line, the figure that is outside of has landed outside of the bracket, it was nonetheless not negligent. That's the way, my lord, it is put in the cases, and that's what we urge upon the court in this appeal.
But the question of the evidential burden is just, all that does is say, it's actually a misnomer in many ways. The expression the evidential burden and its shifting has been said in many cases to be something of a misnomer. What it's really saying is, if nothing else were said, it would be open to the court to find on that piece of evidence that the legal burden was discharged. But it's just a piece of evidence, and it will be weighed at the end of the trial with all the other evidence. The legal burden not having shifted. Well, I mean, because at some points in your skeleton, you seem to say, for example, paragraph 19, I think, that if you fall outside, that it is the bracket, it's determinative of liability, and then you say in brackets, at least subject to any further defence the valuer might rely on. I mean, that's putting it far too high, isn't it? Well, it's not a question. I mean, to say as you do in paragraph 19 of your skeleton seems to cast it as almost as if the legal burden's shifting and it's, quotes, determinative of liability subject to a defence.
Well, my lord, I accept the word determinative. It does put it too high. But it is a shifting of the burden which, in practice, creates a presumption. As your lordship says, if there is nothing more, the fact that the figure is outside of the bracket, it must logically follow that the defendant has been negligent. And what the cases show is that it is then, and as Mr. Justice Watkins put it here, it is then for the defendant to explain to the court why a figure that is outside of the range or bracket is nevertheless not negligent. That's clearly what Judge Langan was saying in this judgment, and as we'll see in a moment, that was accepted and adopted by Lord Justice Buxton in the Court of Appeal in Merivale. So if I can turn now to Merivale behind tab 2. This was a case in which Strutt and Parker advised the claimant about the purchase of what was described as a commercial development opportunity in respect of a building on Portland Place. And what was on offer to the claimant, what was being sold, was a lease with a 46-year term remaining. And it was valued by Strutt and Parker at £11.5 million on the basis of an estimate of the rent that would be received from the developed property and a yield that was applied to that rent to lead to a capital valuation. And the plaintiff bought relying on that valuation and made a loss. Now, in the Court of Appeal, it was argued that the judge's conclusion that the valuation was negligent was wrong for two alternative reasons. The first was that the judge had been wrong to find that the rental element adopted by Strutt and Parker in its valuation was wrong. And the second was because the yield that was adopted wasn't subject to a qualification, to a warning that there was an unusually high risk in adopting a yield for a property of this sort where there's very little market for leases of that sort of length of this type of property. So they were the 2 points that were before the Court of Appeal. And what I want to take your lordships to is the discussion by Lord Justice Buxton of the approach of the court to negligent valuation, which begins on page 30, which was in the context of his consideration of the first of those two grounds of appeal. And under the heading negligent valuation authority, he refers in the first paragraph to the Singer and Friedlander case and says in the final sentence that has led to the courts adopting a particular approach to claims of negligence on the part of valuers. He then cites from Lord Hoffman referring to the Bolam test, and then picking it up at letter E. He says, however, where the complaint relates to the figures included in a valuation, there is an earlier stage that the court must be taken through before the need arises to address considerations of the Bolam type. Because the valuer cannot be faulted in any event for achieving a result that does not admit of some degree of error, the first question is whether the valuation as a figure falls outside the range permitted to a non-negligent valuer. And then he cites again from Mr. Justice Watkins in the Singer case, there is, as I have said, a permissible margin of error, the bracket as I've called it, what can properly be expected from a competent valuer using reasonable care and skill is that his valuation falls within this bracket. And then at G goes on to say, a valuation that falls outside the permissible margin of error calls into question the valuer's competence and the care with which he carried out his task. And then I think I've come to the conclusion, my lords, that something must have gone wrong with the words at the beginning of the next sentence. I'll stand corrected if that's not the case. But the way it's recorded is, but not only if, but only if.
Yes.
The valuation. I think it must be, but only if. Oddly, all, and there have been a number of them, subsequent citations of this, have copied it verbatim. But it should be, but only if the valuation falls outside that permissible margin does that inquiry arise. That is what I take to have been the view of Lord Justice Balcombe, with whom the remainder of the members of this court agreed in Craneheath. And then at letter B on page 31, he refers back to the legal and general case. He says, as it was put by Judge Langan in legal and general, in an analysis that I have found helpful, once it is shown that the valuation falls outside the bracket, and then he cites the passage that I've already read out, about the plaintiff having discharged an evidential burden, and it will be for the defendant to show that notwithstanding that the valuation is outside the range within which careful and competent valuers may reasonably differ, he nonetheless exercised the degree of care and skill which was appropriate in the circumstances. So that, my lords, is the acceptance and adoption by Lord Justice Buxton in this court of Judge Langan's suggested approach based on all of the earlier authorities, that an evidential burden shifts, and in those circumstances it is for the defendant to show that the valuation, which has fallen outside of a bracket as determined by the court, is not negligent. He then sets out a number of considerations.
But clearly, but again, just to reiterate, but clearly there's no shifting of the legal burden. It's just what is sometimes called the evidential burden shifts.
Yes, I accept that. We have to accept that. It's never been the case on this side that the legal burden shifts. In the passage that follows, he sets out 4 considerations. I don't propose to read through all of them. I should just make reference in passing to what is described as the third, just below letter E, where Lord Justice Buxton put it in this way: where the valuation is shown to be outside the acceptable limit, that may be a strong indication that negligence has in fact occurred. That is said in Mountbanking at 145J. The judgment in that case was commended in general terms by Lord Justice Balcombe in Craneheath, but it's not clear how far that commendation extended to all the specific elements in it. Some caution at least has to be exercised in this respect, because the question must remain in valuation as in any other professional negligence cases, whether the defendant has fallen foul of the Bolan principle. To find that his valuation fell outside the bracket is, as held by this court in Craneheath and also I consider by the House of Lords in Bunk Lambert, a necessary condition of liability, but it cannot in itself be sufficient. And I read that out because that's held up both by the judge, as we'll see in a moment, and also by the respondent, as showing that the...
Which page are you?
This is page 31, between letters E and G.
Yeah, thank you.
And that passage is held up by the respondent, as well as, to some extent, the judge, as showing that Lord Justice Buxton was not, in effect, adopting the approach laid down by Judge Langan in Legal and General. But what we say to that is that, having not only cited it at letter C, but described it as a helpful analysis at letter B, but what he is saying there must be subject to the description at letter C, namely that...
Well, if you keep your eye on the legal burden and treat the evidential burden for what it is there much tension between the two?
Well, we say not, but it is held up against us, and the judge cited specifically from the passage at letter F to demonstrate that there is no shifting of the evidential burden in the way that it's described by Judge Langan in the citation at C on this page. Now,
So do you say that he didn't mean the sentence at F to find that his valuation fell outside the bracket is, as held by this court in Crane Heath, and also I consider by the House of Lords in Banque-Lambert, a necessary condition of liability, but it cannot in itself be sufficient.
In order to marry that with what he has said at B and C, my lord, we say that he must, the phrase "it cannot itself be sufficient" must mean that there is a shift in evidential burden and that the defendant can show, where appropriate on the facts, that notwithstanding that the valuation has fallen outside of the bracket, it is not negligent. But that is for the defendant to show.
I mean, it's different, isn't it, depending on whether, on this type of valuation. I mean, you could imagine a valuation where the valuer is given copious reasons, and they're all complete rubbish, right, and totally negligent. But the valuation fortuitously, because competing mistakes have been made, comes out rightish,
Yes.
within a bracket. And you say that, what do you say? None of that matters.
No, we say if it is within the bracket, then the claim fails. We don't take issue with that. And that was the result in a number of these cases,
Yeah.
that it was within the bracket. We're dealing in this case with the converse of that, where it is outside of the bracket.
And if you're right on ground two.
Indeed, or
Ground
or any of the other grounds, really. I accept that, as I have to, if your lordship's on with me on any of grounds 2, 3, or 7, then this issue doesn't arise in this case.
If the valuation falls within the bracket, picking up my lord's point to you a moment ago, if even though there are a whole raft of careless errors, but which cancel each other out, and you fall within the bracket, and therefore the ultimate valuation falls within the bracket, you accept that the valuer isn't liable.
Yes.
Why is that?
Because, and this is put quite graphically, quite clearly in the K.S. Lincoln case by Mr. Justice Cawson, what matters in a valuation, what matters where somebody, for whatever reason, has instructed a valuer to value something.
Sorry, my question wasn't clear enough. Is it because it's only the overriding duty of the valuer is just simply to get a result that falls within the bracket? Is that the actual duty? And therefore, if you were within the bracket, even if you've been careless along the way, there's like some overarching duty that you've satisfied, which I think is a suggestion that we've already seen and will come back to, and we would definitely see if we looked at Goldstein. Or is it that, in fact, the valuer has been negligent, he's failed to exercise due skill and care in a whole raft of things, but because perchance the result is within the bracket, there's no loss, and therefore, and that's because you assume when you're determining damages that the contract is performed in a way that minimises loss and damage. I mean, how do you actually, what is the correct conceptual underpinning to the bracket?
We say that it's a question of duty. We say that it is the valuer's duty is to produce a valuation that is within a range of values that could be alighted upon by a reasonably competent valuer. That really, my lord, is the essence of the bracket.
Or is it to produce a value that's within the bracket, or is it to exercise due skill and care?
Well, to exercise it's to exercise due skill and care in and about the valuation. And the bracket is a mechanism that the court adopts to determine whether or not the valuer has complied with that duty. So I recognise that they're two slightly different ways of putting it, but they amount, we would say, to the same thing. Ultimately, what is required of a valuer is to alight upon a figure, where what we're dealing with are figures, which is within the bracket and not outside of it. Now, what I propose to do now is to take your lordships briefly through 4 of the subsequent authorities addressing how this issue has been dealt with in subsequent cases. Now, I'm mindful of your lordship's concern about the omission of certain other cases from the authorities bundle,
Well, I find it very helpful to see authorities in chronological order, because then you can get an idea. Which of the 4 cases, anyway?
Well, I was proposing to take your lordships to, in chronological order, KS Lincoln behind tab 3, the Capita case, Webb Resolutions, and Titan and Colliers.
Right. And Goldstein when was Goldstein?
Goldstein was sometime between Merivale and KS Lincoln, and the Dennard case, which your lordship decided, was I think.
The Goldstein comes next in time, in fact.
Yes.
And then Dennard, I think.
Well, I think KS Lincoln was I'm not sure of the exact date of Dennard. They were both
2009.
So yes, so
I think.
Dennard was actually April 2010.
2010. Oh, right.
And Lord Justice, Mr. Justice Cawson was May 2010.
That's right.
So the order of these cases is Lincoln, and then Goldstein. I mean, why don't we look briefly at Goldstein next?
Goldstein is one of the cases that isn't in your lordship's bundle.
No, it's on my screen though.
Right.
Have you got it? I'll send it.
No, I've got it.
You've got it.
I've got it up on Bailey.
I can get it.
On Bailey.
I'll send it.
I've got it.
Got it.
So Goldstein was a case where the valuation that was impugned was that of the shares in a property company following a shareholder being made redundant, and an obligation under the articles to sell those shares at a value to be determined by the company's auditors. And the shareholder, Mr. Goldstein, contended that the valuation was too low. Mr. Justice Lewison looked at
Look at Merivale at paragraph 58.
Yes, he began with Merivale at paragraph 58.
In fact, the whole of the relevant passages from Goldstein are actually set out verbatim in Dennard, aren't they?
I think it's slightly abbreviated, but it is substantially set out. Paragraph 135.
Yeah.
Now, what Mr. Justice Lewison says, he explains the facts in Merivale in paragraph 58, and then in the last 6-7 lines of that paragraph, he says that the result of the appeal, therefore, was that although the valuer had adopted a rental value which was not negligent, and a yield which was in itself not negligent, he was still liable in negligence because of the failure to qualify the yield with a warning. Simply looking at the result, one might have thought that this was a case in which the process, rather than the end result in figures, was all important. However, examination of the judgment of Lord Justice Buxton shows that this may not be so. And then he goes through the various parts of Lord Justice Buxton's judgment. And then at 63, what Mr. Justice Lewison said was this. It is clear that Lord Justice Buxton holds that in cases where the figures are impugned as figures, it is a necessary precondition of liability that the impugned figures fall outside the bracket. That being so, it's not easy to see why, at that stage of the inquiry, it matters whether the valuer has adopted an unprofessional practice or approach. Either his final figure falls within the bracket, or it does not. If falling outside the bracket is a precondition of liability, why should it matter how the valuer arrived at his figure, as long as it is within the bracket? There is, I think, another problem. If the bracket is the end result, and the end result depends on a number of variables, should the bracket be assessed by arriving at a bracket for each of the variables, or only for those variables that are alleged to have been negligently assessed? Logically, in my opinion, the approach in Merivale Moore leads to the first possibility. Then he says, the passage quoted from the judgment of Lord Justice Buxton is, in my view, part of the ratio of the majority of the court. It unequivocally emphasises the decisiveness of the end result, as opposed to the process by which the valuer reached the end result. It also interprets Lord Justice Balcombe's use of the word wrong as meaning outside the margin of error, as opposed to incorrect. However, it seems to me to be confined to a case where the complaint is about the figures as figures rather than some other aspect of the valuation. And just pausing there, the distinction that is made by reference to Merivale Moore is between the two grounds that were before the Court of Appeal in that case. The first ground was that the judge in that case had got his assessment of the rental value wrong. The second ground was that the judge was wrong to conclude that the stipulation of the yield in that case, without a suitable qualification or warning, was negligent. And what I would suggest Mr. Justice Lewison is getting at there, by reference to Merivale, is the second ground in the Merivale case, where the valuation was held to be negligent, not because of the conclusion on the figures, but rather because the figure that was produced was not appropriately qualified by a warning. I would suggest, my lords, that Mr. Justice Lewison, in recognising that the passage that I took you through in Merivale is ratio, and accepting that a first instance court is bound by it, was accepting and adopting the approach that was laid out by Lord Justice Buxton in Merivale. And that approach, as I've set it out, includes this shifting of the evidential burden and the fact that the court is concerned primarily, or first and foremost, I should say, with whether or not the impugned valuation falls within an appropriate bracket. And only if it does not, is it then for the defendant to show that the defendant was nevertheless not negligent. So we say that there's nothing in Goldstein that takes matters any further forward.
Well, in 69, he explains the point that I asked you about right at the beginning, about speaking and non-speaking awards. He says, Mr. Howe goes on to argue that even if the distinction drawn by Mance is right, this is a case in which all that the EVG were required to do is produce an end result. He says with force, in the normal case, a valuer produce a non-speaking award. The reasoning process should not be subject to independent scrutiny. The inquiry should focus on the final figure. The practical difficulty with this submission is that both experts arrived at their final figures by considering the component parts separately. In order to reach a conclusion on the validity of the final figure, I have to replicate the process. And then he says, it seems that I must embark on the same exercise as Lewis and, sorry, that's me, says, I said, I'm looking at it in Denard, but I then said, I've got to go and do what he did, which is replicate the process. So it depends, according to the way these cases look at it, on what the valuer was asked to do.
Well,
and I don't know what the valuer was asked to do here. The valuer was asked to just produce a figure, is that right?
yes, we haven't reproduced the contract, the option that contains the expert determination clause, and we can get
but
that.
It's a Red Book valuation in which you do have to state your reasoning, don't you?
I think from memory that's right. But
So don't you have to, for the purposes of persuading us that the judge got this wrong, don't you have to show us that the type of case that we're talking about?
Well, we say that that is a matter simply of the process that the court adopts. That the process doesn't differ from one case to the next, whether in one case there is what Mr. Justice Lewison describes as a non-speaking valuation or whether there is a speaking valuation. That just goes to the evidence and the reasoning that's put before the court, both for the purpose of determining the bracket, which is done on the basis of the expert evidence called by the parties at trial, and if there is what's described as a speaking valuation, then necessarily that will also engage reference to the valuer's reasoning, as opposed to a case where there is a non-speaking valuation and all the court will have before it will be the expert evidence that the parties have called at trial to determine the bracket. But the principle that the court starts off by looking at whether or not the figure is within or outside of the bracket it is no different in either case. There may be a difference as to how the court works out the bracket, but again, that's just the court taking the most appropriate approach on the facts of a particular case. But the overall principle that one starts by working out whether or not the impugned valuation, the figure, is within an appropriate range. And if it isn't, one then looks to the defendant to justify the figure, notwithstanding that it's outside of the range. We say is the same whichever type of case one is dealing with.
And justify, I think that's the first time we've used that verb. What do you mean by justify?
Demonstrate that it, I'm sorry.
Demonstrate.
Loose language, demonstrate that it is non-negligent.
I mean, those sound like verbs meaning prove.
Prove that it's non-negligent, yes.
I mean, I just don't understand this at the moment because it seems to me so obvious. Of course, the starting point must be to show whether it's because of as a matter of loss, as my lord suggests, or as a matter of negligence. The starting point is that you can't make a claim if you can't show that the value is outside the bracket.
Yes.
But if the defence to the claim is, as it I think nearly always is, we did a proper job, then there is an attempt to discharge the evidential burden that's shifted to the other side, always. And then the claimant has to discharge the legal burden of showing, as the judge here said, surely, that he fell below the standard, because if he got a figure that was outside the range, but also he did a perfectly proper job, he wouldn't be liable.
Well, my lord, all of that necessarily follows that I think that the difference between the parties is as to which of the two parties has to persuade the court that, as your lordship put it, he did a proper job if his valuation is outside of the bracket.
Well, you have the legal obligation and he has the evidential obligation. I mean, obviously, because you don't know if it's a non-speaking valuation.
But even, we say that the position is the same even where it is a speaking valuation. Because, as Mr. Justice Cawson put it, what matters...
You've still got the legal burden of showing that he was negligent. I mean, you can't get away from Bolam.
No, absolutely, and I've made clear we don't seek to get away from Bolam.
Although your skeleton, you see, in many cases does suggest that. I mean, if you look at the last sentence, paragraph 45, which is your conclusion in this respect, you say, on the basis of the above authorities, and in particular the decision of the Court of Appeal in Merivale, all that a claimant has to prove is that the valuation was outside of a reasonable bracket. I mean, you say you're outside the bracket, that's it, end of case. I mean, that's not what you're actually saying, is it?
Well,
Can't be the case. That can't be right.
well, my lord, that we say is what flows from the way it was put by Judge Langan in Legal and General and adopted by Lord Justice Buxton in Merivale.
Which particular precise point in Lord Justice Buxton's judgment do you rely on for that?
I mean, what in fact he says. Sorry, I'll
I think my lord's about to answer my question for you.
Well, I'll take the question from whoever wishes to
no,
ask.
you stick
It's awful, isn't it? Take my lord's question.
No.
No, well, let's go to
Where is
It's
it?
page 31,
Where is it?
B to C.
Sorry?
Page 31, Authorities Bundle, B to C.
That doesn't answer, that only answers part of the question.
Because what in fact he says just below E is where the valuation is shown to be outside the acceptable limit, that may be a strong indication that negligence has in fact occurred. I mean, he's putting it no higher than. It's a piece of evidence.
And it goes on at F.
Well,
Refers to Bolan as my lord just said.
Well, as I said earlier when I took your lordships to the passage at E to F, my submission is that has to be read subject to the acceptance of what is stated clearly by Judge Langan in the citation at C.
I mean, cases never turn on burden of proof, as we know. Burden of proof is all very interesting. If the issue raised in the case was the valuer negligent in a particular respect, and that is normally the issue, right? I mean, in all the cases we've looked at, there are two complaints, substantive complaints made about what the valuer did, and one or the other, is wrong or not wrong. That's the Bolam inquiry, which is going to take place. I mean, the difficulty that I find, the conceptual, juridical difficulty, which, I mean, I'm not desperate to resolve, but it is a juridical difficulty, is how it can be the case that a value can fall outside the range that a reasonably competent valuer could have come to, and yet, in some cases apparently, be done by a reasonably competent method. Now, I don't understand how that can be the case, so that is problematic and is caused by this idea that seems to be deeply embedded in our law, that for valuers we have a different idea of what negligence is. Because you can't have it both ways. Either the valuer's got to do something wrong, bolum, or the doing of something wrong in getting the wrong figure is enough. I mean, and we're all struggling. All these cases are struggling with that, aren't they?
Yes, and that is what I think was described in the judgment as the logical inconsistency. And the judge himself...
Where does he, which para is that? That'd be useful to look at. I'm sorry to take you out.
No, not at all. I think my note says paragraph 161 in the judgment, so that would be core bundle, page 108.
He talks about logical fallacies.
And he refers back to submissions that he recited earlier in the judgment. I think the reference to 80 should be to 82.
A para 82.
Para 82 on page 95.
Yes.
And then where he says, I have already identified that Mr. Allen takes the point about the logical fallacy, that's going back to 67.
And you said 137, did you?
Paragraph 67, I think, is the one that
What?
has,
Yes.
67 is the clearest
Yes.
indication of identification
Yes,
of the
it is.
logical problem my Lord has put.
Yes, it is.
Yes.
It must follow from the approach that is advocated, or we say is advocated in these authorities, that it would be an exceptional case where the valuer can show that a valuation that is outside of a range of values that a reasonably competent valuer could have alighted upon is nevertheless not negligent. But there are, one can conceive of scenarios where that might be the case. I think, I don't have it at my fingertips, I think somewhere in the judgment that the judge suggests that it could be a case where the valuer has been misled about certain information, or one might develop that to a scenario where the valuer couldn't reasonably have obtained certain information that is considered by the expert evidence before the court. I suppose a valuer could rely on a qualification in the valuation of the sort that was absent in Merivale. So the argument against the valuer is that the figure, the bottom line figure, is outside of the range. And the valuer says, well, yes, it is outside of the range, but you haven't taken into account my qualification, that my warning, that figure has to be taken with some caution because of the state of the market or the absence of comparables or such like. So there could be reasons that in a particular case a valuer advances to discharge this evidential burden or to rebut.
Yeah, but those reasons are a substantive defence, and they explain only why it was outside the range.
Yes.
And so it's a substantive defence. So it doesn't answer the logical fallacy, which says the only thing you need to show is it's outside the range, and also Bolam requires you to show that what you did was what only was within the bounds of a reasonable, competent valuer. And that is a logical fallacy. I don't know how we resolve it. But
well, I mean, my Lord, the way I would put it, the way I would put it is that the range sets up a prima facie case that the valuer has failed the Bolam test. It's not conclusive, it's a prima facie.
Necessary but not sufficient.
That's another way.
That's what Lord Justice Buxton said, isn't it?
Yes, I think that's right, my lord.
For public policy reasons, is it? Is that why is the bracket there at all?
Well, it is a mechanism that developed for the courts to apply the Bolam test to a professional who is charged with producing a figure, producing a value for an asset.
But the reason the wonderful Lord Justice Tasker Watkins said was because, and he was a man of some considerable directness, and he said, well, this is not an exercise in pinpoint accuracy. You're just being asked for a figure. You're not being asked for anything else, and therefore you can't criticize them unless they got the figure wrong. I mean, it has supreme logic. However, it doesn't engage with the law of negligence. And what I'm worried about here is that these cases don't give a sufficiently sustainable juridical path for the way you're supposed to work. I mean, if the whole exercise has a logical fallacy in it, then we've got to think again. And I think the thinking I did in Dennard, I mean, I haven't looked at Dennard for a long time, but I've just got it on my screen, was to say this is a question of loss.
134, paragraph 134.
And I think what I said was, you have two elements in a tortious claim. You have breach of duty and loss. And the reason why you can't claim if you're inside the bracket, even if there's been any amount of negligence, like my case, where you get everything wrong, but you happen to see one goes that way and one goes that way, which happens in valuations, and you come up within the bracket by sheer chance, is because you haven't suffered any loss. Now, I just want to know why that's wrong. I mean, it sounds persuasive. It would sound persuasive,
of course,
to me, wouldn't it?
I'd have to go back to Dennard, which I have somewhere on my screen, to respond to your lordship's point directly. I don't have that at my fingertips, so but perhaps I can address the court on that later. But in terms of the duty, I come back to what Lord Justice Buxton said, combined with Judge Langham. In this court, so it binds first instance courts, bound Mr. Justice Lewison, even though, as your lordships have understandably pointed out, Mr. Justice Lewison had difficulties with it, but it bound Mr. Justice Lewison, it binds this court, as the approach that the courts are required to take in order to apply Bolam to a charge of negligence.
But I mean, on any basis, not only did Sir Christopher Staunton dissent, but on any basis, it's not easy to understand Merivale.
Well,
because it says one thing and then contradicts it.
Well, my submission on that, my lord, is that the two passages that your lordship refers to are to be read together. They're not necessarily, the latter is not necessarily a contradiction of the former if they are read together.
But the problem you've got is that they simply expose the logical fallacy. So we have to confront, I mean, we don't have to, because we may say grounds 2, 3, and 7 are wrong, and therefore doesn't need to, but if, assuming in your favour that grounds 2, 3, and 7 are right, we have to confront the logical fallacy. And we, it's open to this court to say, well, the previous authority is binding on us, but actually it's not easy to understand, so we're going to tell you what it means. So,
Well, my lord, as I said, I might need to come back on Denard, but it is in order to understand the way and to see the way that Merivale has been applied. It is useful.
let's look at the other
We
four
would
cases.
suggest to look at the subsequent cases.
Okay, let's do that.
So first of all,
KS.
and I'll try and go through these rather more quickly. First of all, KS Lincoln, which is behind tab 3, the first of two decisions by Mr. Justice Cawson. That was a case where the claimants were investment vehicles for investors who were buying hotels in the UK, and they were held on leases which contained a rather strange turnover rent provision. So conventionally, they had a provision for a base rent plus a turnover rent. But the turnover rent only became payable when the turnover exceeded a certain level. And there was an odd provision in these leases that the tenant was entitled to carry forward the benefit of earlier periods where the gross turnover was below that level. So on any reckoning, it could take a number of years before the tenant of the hotel's turnover hit the required level. And the defendant valuers valued the hotels, but they didn't take into account in that valuation the carrying forward of the previous periods of turnover. And there were two elements to the claim. First of all, it was argued that the claimants would not have invested if they had understood this unusual feature of the leases. That element failed on the basis that the judge held that they were aware of it and did understand it. But the alternative claim was that the valuations themselves were negligent, and it's that aspect of the case that is relevant. And Mr. Justice Cawson looked at the law, paragraph 139 onwards, beginning on page 78. And paragraphs 139 and 140, he sets out what he describes as the debate between, on the one hand, what is set out in Jackson and Powell at 140, that the bracket is a necessary condition for liability, and on the other, in the professional negligence and liability text, that all that matters is that the valuer gets the process right, and that evidence of the figure can't show whether or not this duty has been fulfilled. That's the last two lines of the citation. And then picking it up at 141, Mr. Justice Cawson says, it's not the purpose of my judgment to reinvent this particular legal wheel. That's partly because I believe there to be Court of Appeal authority binding on me, which gives a clear answer to this question, partly because this issue has recently been considered and, in my view, resolved by Mr. Justice Lewison in Goldstein, and partly because I've reached a firm conclusion of my own which is consistent with these authorities. All point in exactly the same way that whilst a valuer might be in breach of duty because he fell below the standard of a reasonable valuer in his methodology, that valuer will not be liable in negligence if it can be shown that, notwithstanding the error, the valuation figure that he produced was within a reasonable bracket. And then he sets out extensively the citation from Merivale.
Well, hang on. That's quite interesting.
The way Mr. Justice Cawson puts it at the end of 141 is he puts it slightly differently.
Well, I mean, that it seems to be buried in there is that he won't be liable because there wasn't any loss. I mean, if there's a breach of duty, I mean, there are two elements to the tort of negligence.
Yes.
Breach of duty and damage.
Yes. But
So
that
But I mean, he doesn't say that because I don't think he'd seen Denard, had he?
he hadn't seen Denard.
No. But I mean, isn't that what? Does Goldstein not say that?
No, it doesn't. Or
It doesn't say that.
we wouldn't accept that that comes from Ms. Justice Wilson in Goldstein.
Okay.
He then goes on at pages 79 to 80 to set out extensively the citation from Merivale. And then at 144 he says, it seems to me plain from that analysis that Lord Justice Buxton, with whom on this point Lord Justice Norse agreed, was making it plain that a discrete breach of duty in arriving at the valuation figure would not give rise to liability unless the valuation figure produced by the breach was outside the permissible bracket. Subject to the next issue, I consider that that conclusion is binding on me, and then at 145, he accepts, or he concludes the point having been taken, that it wasn't, that it was in fact part of the ratio in Merivale.
He comes back to the loss point at 151.
Yes. Drawing on his own experience in this area.
I mean, what he expresses, without reading it all out, in 149 and 150, is that what is at issue in a claim against a valuer is the result.
Yeah, but he does pose the question with use reference to loss in 151. Where what loss would be caused. Save in an exceptional case, if the valuation was within a reasonable bracket, any discrete breaches would not have caused any loss, and therefore there could be no finding of liability in any event. So that's his own.
And 152 is precisely what example we've just been putting to you.
Well, indeed. But we say that the reason that example doesn't work is because the valuer is not in breach of duty if the valuer gets to a figure that is a figure that the court concludes.
But that goes back. But that goes back to a proposition I put ages ago to you, that what is the duty? Why do you say? Why is it said that in this area the valuer's duty is to just reach a figure that's within a bracket, as opposed to the way it's conventionally put, which is a valuer has a duty to take reasonable care in producing a figure? I mean, you didn't ask, I assume we haven't got the letters, I think you said, you didn't instruct the valuer just to produce a figure that's within a bracket that might be arrived at by reasonable valuers. If you'd have actually written out what you were asking him to do, you would have said, please will you use reasonable skill and care in giving us a figure for the value of this property. Why is that any different to any other expert? You know, why do we suddenly start casting the duty in terms of arriving at a sort of figure that's within a range that a whole load of other people might have got to? The actual isn't the actual instruction, if you were to write it out, please use reasonable skill and care to give us a figure.
Indeed, and that's why we say that the bracket is simply a mechanism that the courts have developed for establishing whether or not the valuer has breached that duty. That's the way this bracket has evolved, and it's there to enable the court to get at the Bolam question, to get at the question of whether or not the valuer has acted with reasonable skill and care. If the valuer's bottom line is outside of the bracket, then it's presumed that the valuer has acted without skill and care. It may be that there are circumstances that demonstrate that that's not the case. But the bracket is just is a mechanism that the courts use in this type of case to answer the Bolam question. Given, as Mr. Justice Cawson explained, the differences between the professional or the nature of the professional duties of a valuer and the nature of the professional duties of other professionals.
He doesn't characterise it as breach of duty. In 141, he characterises it as liability. In other words, he says there may be breaches of duty, but if it's because he fell below the standards of a reasonable value in his methodology,
Yes.
but he won't be liable in negligence if, notwithstanding that error, he's within the bracket.
Well,
And that's a loss.
well,
Characterisation of it, as my lord articulated subsequently in Denard.
my lord, we say that, or to that extent, that is not how it was put by Lord Justice Buxton in Merivale, for the reasons I've endeavoured to outline. And it's also not the way that it's described, that the principle is described and applied in later cases too. I'm conscious of time. What I would propose to do is just to take your lordships briefly through the other three cases, just to see how the principles are outlined. First of all, Capita, which is behind tab 6, at first instance, Mr. Justice Eder summarised the principles that are to be applied from the various authorities. His section on the law begins under the heading Breach at page 146. And the specific passage that I would refer your lordships to begins at paragraph 145.
So this comes after Denard, doesn't it?
Yes.
Yeah.
Denard is referred to in and amongst the authorities that Mr. Justice Eder is seeking to reconcile in paragraph 145.
We're looking at 145.
Yes, page 148, paragraph 145. And in the second sentence, he says, in this context, there is a relatively large body of authority that addresses the approach to be adopted by the court when considering the question of negligent valuation. He says the authorities aren't always easy to reconcile. Refers to Goldstein, Denard, and K.S. Lincoln. And then over the page at 149, he says the following propositions can be drawn. And he sets out a series of 7 propositions. And it's the 7th that we say piggybacks, as it were, on the passage in Merivale that I have relied on. Where he says, even if the valuation is outside the range, the professional may escape liability if he can prove that he exercised reasonable skill and care. And then if the second sentence is is a converse of that, which doesn't apply.
Yes, but if you look at 3, which you skipped over, where the court is considering whether a valuation is in itself negligent, the claimant must normally show not only that the value fell in some way below the standards to be expected of a reasonably competent professional, but also that the value fell outside the range within which a reasonably competent valuer could have valued. So he's saying the reverse of what you say about Merivale.
Well, again, it's in terms of approach of the court to how the court gets at the answer to this question. That has to be read with proposition 7, which is clear that in the view of this judge, the authorities say that if there is a valuation that's outside the range, it's for the professional to prove that he exercised reasonable skill and care.
What's the authority for the verb prove?
We would say Merivale. The passage I took the court to letter F on whichever page it was, where he is citing from Judge Langham, who talks about the shifting of the evidential burden.
The evidential burden, sorry, I sound like a cracked record. It's simply a it's a misnomer to talk about it as a burden. I mean, I think Syria, I can never pronounce it, says it's actually really not a burden at all. Or it certainly shouldn't be talked about as a burden of proof. Jayasena is the case. It's 1970 appeal cases. It's confusing and misleading to call the evidential burden a burden of proof. That's what Lord Devlin said. I mean, it's simply a statement of what will happen as a matter of evidence at a trial. If you only have on one side, no more than it's outside the range, and nothing more is said or adduced, then the court may conclude that that is sufficient evidence to discharge the legal burden. But as my lord put to you a little while ago, I mean, that's not ever going to be in practice the case. There will always be, say perhaps in a query a non-speaking valuation, but unless it's a non-speaking valuation, there will always be some evidence as to how the valuation was done, which might demonstrate it was carefully done, but just arrived at a result which was outside this bracket.
I think the distinction between what your lordship describes and what is encapsulated in that sentence in Proposition 7 is who has to come forward, who is required to come forward with that evidence. If I'm a claimant claiming that a valuer I've appointed has valued my property negligently, and I adduce evidence to the court to show that the bottom line valuation is outside of the range, and I say nothing more, then it would follow from that that I get a finding from the court that the valuer has acted negligently.
No, it doesn't follow from that. If you say nothing more, that's your case. It will then be for the court to decide, having regard to all the other evidence that might be adduced in the case, whether the one factor you've pointed to is determinative or not.
Well,
if you want to rest on your laurels just by showing that it's outside the range, well, great, but you may not win. And that's because you still bear the legal burden, and there may be evidence going the other way. I mean, it's difficult to slightly imagine how, and that's the logical fallacy.
Well, the how is the kind of defence we've been talking about. I was misled, or
indeed,
different comparables weren't available, blah, blah, blah.
Indeed. And that's where we say the judge went wrong in this case, because he accepted that there were certain things that were wrong with the valuation by reference to his own valuation of the site. We'll come to the judgment in a moment. But because those mistakes hadn't been advanced by the claimant, the judge said that they couldn't lead to a finding of negligence. That's the difference. It's a question of, I'm not going to use the words evidential burden because I know your lordship doesn't like it. Even though that is the way it's put in the case. It is where it is established that a valuation is outside of a bracket, and nothing more. There is an effective presumption. And if I, as claimant, say nothing more, it is for the defendant to come to court to show that, notwithstanding that, I wasn't negligent. And so that's why I described it as the mechanism or the process for applying Bolan in these cases. Very briefly...
Titan you wanted to go to,
Sorry?
there were two other cases you were going to cite.
Yes. First of all, just in passing, because there isn't a huge passage in it, but there is a nevertheless relevant paragraph commenting on this by Mr. Justice Cawson in Webb behind tab 6. Page 260, paragraph 23, under the heading "The Law Relating to Negligent Valuations."
Yes.
And at the end of paragraph 23, he says it doesn't follow that if the valuation is outside the reasonable margin, the valuer was automatically negligent. It immediately spotlights the way in which the original valuation was performed and provides a prima facie case for the valuer to answer. And then in Titan, we find similar summaries behind tab 8 at page 344, paragraph 6 of the Court of Appeal's judgment of Lord Justice Longmore. And he's there recording the legal principles that the trial judge applied. And at number 3, he says, not every error of judgment amounts to negligence. In order to establish negligence, a claimant must prove that the disputed valuation was one which no reasonable valuer would have reached and was outside the permissible margin of error. Then at 4, permissible margin of error, or the range within which a reasonably competent valuer could have valued the asset, is often referred to as the bracket. If the valuation is within the range, then the valuation will not be found to have been negligent, even if some aspect of the valuation process can be criticised as having fallen below reasonably competent standards. In each case, the court must assess what it regards as being the competent valuation and what it regards as being the size of the permissible range. And then, dropping down a couple of lines, whatever the range may be, the court must still form a view as to what the correct valuation would have been, i.e. the figure which it considers most likely that a competent valuer would have put forward. Even if the valuation is outside the range, the professional may escape liability if he can prove that he exercised reasonable skill and care. So, again, this is, all of these passages put it in terms of the process or mechanism in these cases that's been established being a two-stage process, effectively. First of all, it is for the claimant to show that the valuation is outside of the bracket. If the valuation is outside of the bracket, then it is for the defendant to show that it was nevertheless a non-negligent valuation. And that is the way this line of authority has been interpreted in all of these cases. And Titan is in fact an example of a case where at first instance, and indeed on appeal, the court approached the finding of negligence solely by reference to the bracket. So the court considered, first of all, the correct valuation on the evidence, and then a bracket. And then at first instance, the trial judge concluded that the correct valuation was outside of the bracket, therefore it was negligent. And on appeal, the same process was followed, but it was considered that the valuation was within the bracket and therefore not negligent. But it is the approach or the mechanism that I've suggested flows from these authorities that was adopted in that case to the facts that were before the court. Now, what I would like to do next, very briefly, before I move on to my other grounds, just go to what the judge did on this issue in our case. The core bundle, tab 7, begins at page 108. Paragraph 160. he says in the second line, I am satisfied that liability for negligence on the part of a valuer cannot be determined simply by reference to the value of the relevant property as determined by the court, and an application of a margin of the kind identified as applicable to non-negligent valuations by Mr. Justice Cawson in K.S. Lincoln. At least that is unless, and then he sets out 3 categories of case where he suggests that it could be determined solely by reference to a margin. And in summary, really, we say these 3 categories don't in any way detract from the general principle. They're not exceptions to the principle that he's outlined in the opening paragraph there. The first is there's no issue between the parties, that if the valuation's outside, then liability is established. That's just a question, that's just a matter of the stance that the respective parties take in the case. It doesn't address the question of whether or not the principle, as I've put it, applies. Secondly, there's no real issue between the parties as to the extent of the margin. Now, it's not entirely clear where that proposition comes from, and I would suggest it's unclear how it applies. The nature of the property to be valued and the complexity of the valuation will be factors that go to the size of the bracket. But that's not really, it seems, what the judge is getting at here. And there's nothing in the authorities to indicate that a case where the margin is agreed or the valuation isn't as complex as in other cases, the bracket only then will determine whether the valuer has been negligent. And then number 3, the consideration of the appropriate margin by the court itself involves a determination of the bounds of reasonable professional competence as applied to the steps taken by the relevant valuer. Now, that again, with respect to the judge, is confusing the evaluation of the size of the bracket with the overall approach to determining whether the valuation was negligent. Determining the size of the bracket is one component of the court's task. And it may well be that on the evidence in a particular case, it's necessary to do that by going through the various stages, particularly in more formulaic valuations, such as yield and rent, as we've seen in a number of cases we've looked at. But in that sort of case, which on any view is not this case, the court still has to determine a correct value. So we say that there's nothing in those 3 exceptions, as the judge puts it, that is inconsistent with the bracket approach to determining liability. At 161, the judge refers to the logical inconsistency point. I think I've already addressed your lordships on that. And then at 165, the judge says, having regard to the various considerations above, the question then arises as to the proper approach to be taken by the court.
Wait. Sorry, why have you skipped over 162?
Yes.
Well,
I mean, 162, you have to deal with 162 because 162 is saying Bolam, but if you want to establish liability if you're a claimant, you've also got to demonstrate that outside the range, but it doesn't disregard the fundamental Bolam requirement.
Well,
and so he treats the range as a sort of extra. If you're a claimant, you've got to show 2 things.
Indeed, and he says rather the same thing in his summary of principles in paragraph 165. And it's his. I was going to make the same point by reference to his little 4 in 165.
Okay.
So at 1 to 3, he sets out 3 uncontroversial propositions so far as this appeal is concerned. Then at 4, he's really paraphrasing what he said at 162. If the valuation is beyond the margin of error in relation to the court's valuation and therefore outside the bracket, then the valuer's competence and the care used in his or her valuation is called into question. The court will examine at this stage the question of whether, in reaching a valuation outside the bracket, the valuer has acted in accordance with practices which are regarded as acceptable by a respectable body of opinion in his profession.
Well, just a moment. I mean, that is, he's there quoting Mr. Justice Dove in Barclays, isn't he?
Well, he's referred to
Which
Justice
he
Dove, he's
finds
paraphrasing.
of particular help. Am I right? You're reading
yes.
165, 1 to 4.
He's not quoting. He's not quoting from Justice Dove. He's paraphrasing. He's put it into his own
Yes,
words.
you're right.
And really, it's his little form that sets out the difference between the parties. What the judge has done there is he's really whitewashed from this analysis the reference in the numerous citations of principle in the authorities to the creation of a presumption or a prima facie case for the valuer to rebut. And that really is the difference between the parties here.
Called into question, he uses that phrase in his paraphrase of Mr. Justice Dove, 1654.
What the judge doesn't accept, and although he doesn't address it expressly in this part of the judgment, it's clear from his reasoning on the facts, the judge doesn't accept that if, on his findings, the valuation had been called into question, that it is then for the defendant to explain to the court, to satisfy the court that notwithstanding that, the valuation was not a negligent one. That, my lords, is the difference between the parties on this issue. And it's clear that the judge didn't accept that that is the correct approach to dealing with the evidence. My lords, I've spent rather a long time on ground one. I would propose now to move to grounds 2, 3 and 7.
So the key point, you say, is that he said it's for the claimant to prove what negligence there was, even if it's outside the bracket. And I can only take into account the negligence that the claimant has proved and particularized in his statement of claim.
Yes.
And he should have said the burden shifts, it's for the defendant to prove that he did a competent valuation, and only if he succeeds or succeeds in doing that will the prima facie liability established by being outside the bracket give rise to liability.
Yes.
That's what you say.
Yes.
I mean, that's all intelligible, but it places a vast amount of reliance, doesn't it, on this evidential burden, whereas the normal process in proving negligence is to plead and prove it. And, I mean, what troubles me, to be brutal about it, is that the reality is, as I said earlier, cases are never decided on the burden of proof. And what the reality is really a bit of both, in the sense that you say what you think was negligent about what he did, because that's belt and braces. You say it's outside the bracket, and you got this all round your ear. And he says, I didn't, but he's got an uphill struggle. But he might just say, yes, I did get it round my ear, but I was inside the bracket. So I gave you a reasonably competent valuation. And the authorities seem to contemplate that because of paragraph 1, whatever it was, of Cawson, that you can get all the factors wrong, but so long as you're okay, So the only situation in which it matters that he can prove that he did a competent valuation is if it's outside the bracket, but there is some reason why he did it all right.
That, my lord, is what we say.
Yeah, okay, good. Well, I get that. It's all a bit convoluted, isn't it? One would hope for a clearer bit of law for ordinary people to understand.
Well, before I move on, my lord, we say it is clear. We say it's a claimant shows that the valuation is outside of the bracket because what the ordinary person instructing a valuer is concerned with is the bottom line value.
So there's absolutely no need to prove any Bolam aspect in your statement of claim against a valuer, you say?
Your lordship understand, we put it slightly differently. We say that is the Bolam, that is proving Bolam.
Yeah, well, I mean, I understand you say that, but you don't have to particularize that he got factor 1, factor 2, and factor 3 wrong. And the interesting part about it is when factor 1 and factor 2 and factor 3 all go in different directions and there are warnings to be applied to factor 2 and blah, blah. And that's what the cases wrestle with.
Indeed. And
okay, well, anyway, I've got the point. Thank you.
My lord.
And so ground 2.
Ground 2 goes to the judge's decision on the bracket itself. And your lordships will have seen the in various places, I anticipate, that the passage that was referred to by the judge from the judgment of Mr. Justice Cawson in K.S. Lincoln, which is on page 87 in the authorities bundle, tab 3.
Sorry, can you give me the page number again?
Page 87.
Thank you. Yeah.
And Mr. Justice Cawson at paragraph 183 says, as a matter of general principle, the position to be taken from the authorities is as follows. Standard residential property margin of error may be as low as plus or minus 5%. Valuation of a one-off property margin of error will usually be plus or minus 10%. And if there are exceptional features of the property in question, the margin of error could be plus or minus 15% or even higher in an appropriate case. Now, we'll have a look in a moment at what the judge did. But in terms of the nature of this exercise, it's described in Titan and Collier's as a question of law.
But that's wrong, isn't it?
Well, the reference to that is page 345 in the authorities bundle.
345.
345, yes.
I mean, that's wrong. It's an evaluative question based upon the fact, the evidence.
Well, I accept that it is an evaluative determination. So I don't hold up the passage in Mr. Justice's judgment as a tariff, as it were. But it was described by him as a matter of general principle. It is clear guidance. And what is... and within this exercise, as explained at the very top of page 345 in Lord Justice Longmore's judgment in Titan.
Yeah, but the key part of that is the words, if there are exceptional features of the property in question, which
Yes.
is a purely factual question.
Well, indeed, I have to accept that it is an assessment based on the facts before the court. So, of course, I accept it is an
I mean, you
evaluative
elevate, in your
determination.
skeleton, you elevate that. First of all, you say it's Lord Justice Longmore. It isn't. It's a quote from Mr. Justice Blair. And it's a quote from Mr. Justice Blair recording what seems to be something that wasn't in dispute between the parties on the case that he was deciding. So, but it's not Lord Justice Longmore saying it is a question of law.
No, I accept that.
Your skeleton suggests that, and with respect, I think that's just wrong.
No, of course I accept that. But it is quoted by Lord Justice Longmore in his judgment. And the principal importance that I derive from that passage it is what he goes on to say in the second part of that sentence. that it is question of law for the court's determination, assisted by the views of expert valuers as to the degree of difficulty of the valuation under consideration. So the relevance of the expert evidence here is not for an expert to give an opinion of what an appropriate bracket should be, but rather to express an opinion as to how straightforward or otherwise the particular task that the defendant was charged with was in that case. And it's from that evidence, it's from the evidence that's before the court on the facts of each case as to the level of difficulty of the valuation that the judge then has to evaluate the bracket.
Why should the experts be limited in that way? And surely what the judge won't know what, or won't be able to form his own view, or his or her own view, about where competent valuers might come out in valuations of this particular type without experts saying, well, given this has these moving parts, I would expect careful valuers to come out within a range. I mean, if the judge has just told the first bit of that, there are these very interesting, difficult parts, how's the judge supposed to fix the range? Well, he's got to be helped by expert evidence from the industry in question, giving him some sense of where reasonably competent valuers doing this type of job could come out.
Well, what the judge is supposed to do is to apply the general guidance as explained by Mr. Justice Cawson by reference to all of the evidence before the court as to the degree of difficulty or otherwise as to the particular valuation.
But isn't that a bit unreal? I mean, so the expert's supposed to come in front of the trial judge and say, really difficult one, this, Gov. And then the judge is supposed to go away and just have a whole range of expressions of how difficult it was, and then turn up to Justice Coulson's judgment and say, well, okay, that falls within those ranges. Well, that's just that's particularly, if I may say, unrealistic way of thinking that judges are able to do that, because they are not. Judges are not experts in doing the very job that this all relates to.
Well, they're not, but what judges can do is perform the relevant evaluation. The evidence won't be or shouldn't just be, oh, this is very difficult. It will be, there are the following factors featured. These factors made it more difficult than the run-of-the-mill valuation. Or this was a valuation of a house in bog-standard circumstances. Once the court has heard that evidence, it is then for the court to determine what the appropriate range either side of the correct valuation ought to be.
You took us to what Mr. Justice Cawson said in Chaos Lincoln. He went back to this, didn't he, in Webb? Is there anything
He did.
flows from that? So page tab 6, 261. Paragraph 25 onwards.
I mean, he said...
Looking at 26.
He said it's unwise to fix the brackets solely by reference to earlier authorities. Well, I've accepted that. This isn't a tariff for the courts to apply. It's an evaluative decision based on the facts of each case.
So these are rough parameters.
He also says that in that paragraph that in some of the cases the margins were agreed by experts. Yeah. He didn't say, goodness me, they shouldn't have been doing that.
Well, if the
parties... He seems to accept that it is appropriate for the experts to either agree or express a view as to the margin.
Well, if the parties agree that particular aspect of the case, then that's not something that falls for the determination of the court.
No, obviously, but he's not. Your proposition is it is not for the experts to express a view as to the margin. That is for the judge.
Yes.
The experts just say what degree of difficulty it is and what factors are at play. You say the one thing experts should not do is to express a view as to the margin for error in this type of valuation, the margin. And if that's right, I'm surprised that Mr. Justice Coulson doesn't say, or it says what he says in the middle of paragraph 26, without any sort of adverse comment. Because even if the parties experts had agreed the margins, the judge would say, oh, well, I don't care. You shouldn't have been doing that at all. It's for me.
Well, if the parties have agreed one of the ingredients that the court has to determine, then that's not a live issue for the court to determine anymore. But if the parties haven't agreed it, what I'm looking at now is the nature of the evidence that the court takes into account, or ought to take into account. And having an expert, having a valuer say, well, I think a non-negligent valuation is anything 15% either side of the correct valuation, 20% either side of the correct valuation, so within a 30% range or a 40% range, that we say is not for the expert. That is a matter for the court. And then now just to look at what the judge did in relation to this question. Core bundle, tab 7, page 123.
I'm sorry, the paragraph number again?
120. Oh, I'm so sorry. 236 is where it begins.
Page.
Page 123. Now, paragraph 237, the judge correctly directs himself to consider the brackets identified by Mr. Justice Coulson. And he says, at the end of the fourth line, the only expert evidence on this point is from Mr. Buckingham, who supports a margin of error of 15%, on the basis of the Bloxham Road comparable being a good comparable. And I'm satisfied that in the circumstances of the present case, a margin for a non-negligent valuation of anywhere between 10 and 15% is entirely appropriate. Now, his reference to Bloxham Road being a good comparable comes from his report. And I think we need to just go and have a look at the report and see what Mr. Buckingham, the defendant's expert, was saying on this. It's in the supplemental bundle at tab 17, page 202. In the penultimate paragraph on that page, Mr. Buckingham says, for this type of development valuation with many moving parts, there can often be a wide range of opinions, sometimes plus minus 20%. As I say above at section 6, I believe that in this case, with the presence of a sound comparable, the range would have been a bit tighter, with the range of reasonably competent views at around plus minus 15%, for the value of around 4.2 million. Now, what Mr. Buckingham was saying, and what the judge has adopted at paragraph 237 of the judgment, is that, in his view, because there was one strong comparable, and your lordships will have, may have noted, and I'll come to this very shortly, that both the defendant and in his report, Mr. Buckingham, based the valuation of this site on one single comparable transaction, described as Bloxham Road. Because of the existence of that one comparable, that made the valuation more straightforward than it might otherwise have been. And when we go back to the K.S. Lincoln guidance, to what Mr. Justice Coulson said, that the existence of the one comparable does not place this case into the exceptional criterion, the criterion of something exceptional. On the contrary, given that there is what might be described as a golden goose comparable transaction here, from which Mr. Buckingham and the defendant derived the value for the site. It's wrong, we say, to describe this valuation as being within the 15% exceptional category. And so, going back to
When you say wrong, do you say wrong as a matter of law or wrong as a matter of evaluation?
Evaluation.
And so, what's the test you have to satisfy in order to
Well, my lord, of course I'm mindful of the test that this court has to apply in order to go behind a judge's evaluative decision. But we say that where the judge at paragraph 237 derived support from Mr. Buckingham for his conclusion that the margin is 15%, he was wrong in the sense that no judge could have reached that conclusion based on the way that this valuation was undertaken. So just taking a step back.
So you're saying that it was irrational?
Indeed. Because what Mr. Buckingham was doing in the passage I took you to in his report was he was starting from a premise of 20%, which on any reckoning, in my submission, is outside of the Cawson, Mr. Justice Cawson categories. And he brought that down to 15% because this was more straightforward, because you only have one comparable transaction to take into account. There is one ideal transaction that took place of, it is said, a similar site at Bloxham Road, and that enables the valuer to derive the value for the subject site. This isn't a case like, for example, the Dunfermline case that is in the authorities bundle. I don't propose to turn it up. But in that case, the court was also concerned with the valuation of bare land that was sold for development. And in that case, there were no comparable transactions for the valuer to rely on. And the valuer had to rely solely on a residual valuation. And so for that reason, the judge in that case concluded, on the facts of that case, that it was in the exceptional category, and therefore that 15% would be an appropriate bracket. But here, there was lots of comparable evidence, but the judge ultimately got to the point that Mr. Buckingham got to, that there is one sole comparable. And the judge accepted, based on Mr. Buckingham's evidence, that that made this more straightforward.
You took us to the conclusion of Mr. Buckingham's report. His analysis as to the many moving parts which justify the 20%, or might justify as much as 20%, is set out in the body of his report. Why wasn't the judge entitled to accept that?
Well, ultimately, all of those moving parts went, so far as Mr. Buckingham was concerned, to how this one comparable transaction should be adjusted to arrive at a price that a hypothetical purchaser would have paid for this site. Now, that, when valuing a development site, it is, and this was accepted by Mr. Buckingham, this was Mr. Jones's, the defendant's case. That makes this a straightforward valuation of a development site. We're not in the category of the valuation of a house, but there's nothing exceptional about this valuation that tips it beyond the 10%.
Was Mr. Buckingham cross-examined about that paragraph?
He was cross-examined about the exceptionality of this valuation. And yes, he was cross-examined about his 15%, which he stood by. What the judge...
And there's no evidence to the contrary.
No, there was no evidence on this side of the percentage bracket.
So you say the judge should just simply have should have ignored that evidence as to the acceptable margin, or sorry, the margin which reasonably competent valuers could have arrived at in a case of this type.
Indeed, because we say it does not adhere to Mr. Justice Cawson's categories.
And they are cast in legal stone.
They're not cast in legal stone, my lord. I've accepted that. They are, but they are guidance. And in accepting this evidence, the judge, although he's referred to them, he wasn't being guided by the descriptions of those categories.
If Buckingham's conclusion is set out slightly fuller terms on page 194 in the supplemental Bible. Then, I think, is that the right place? Top of 194, just above where paragraph 6.8. I mean, he goes, in fact, the whole of that passage, paragraph 6.7.6, sets out his conclusion.
I beg your pardon, 7.6.
6.7.6 in conclusion on 193. And then leading to the final two paragraphs under that heading at the top of 194, which is a slightly broader summary than appears in the passage in the conclusionary table.
Well, what Mr. Buckingham is addressing in 6.7.6 is how one transposes the price that was paid for Bloxham Road to assess what a hypothetical purchaser would have paid for the subject property. And he's got to a value of 125,250 at the second paragraph of 6.7.6. And then he goes on to say that there should be further adjustments made to that. And he is then looking at a range of values that could be applied in relation to that. And that is what he's addressing specifically at the top of page 194, where he refers to the 20% margin.
Yeah. So what do you say the judge wasn't entitled, or it was irrational or wrong, or however you put it, of the judge to rely on that conclusion?
Because, and that really is replicating what he has said at the end of his report.
Yeah, with a bit more detail. And he explains why it could be 20% because of the reasons he says, but in this case he says 15. So why can't the judge accept that?
Because what he's describing by way of justification for his 20%, it does not fit with the general principles that Mr. Justice Cawson has set out. He's describing something that he says is exceptional, but the underlying rationale for that simply falls away when one accepts that this was a valuation that was based on one sole comparable transaction. That's his ultimate justification. That's Mr. Buckingham's ultimate justification for coming to that conclusion, and that's accepted by the judge. And we say that the judge shouldn't have accepted that as a justification for being within the 15% category. But then if we look at how the judge actually dealt with this, in paragraph 237, what he says in the last sentence is he says, sorry, the penultimate sentence, I am satisfied that in the circumstances of the present case, a margin for a non-negligent valuation of anywhere between 10 and 15% is entirely appropriate. So, I mean, in effect, the judge is setting a range for the range, as it were.
But that's not inconsistent with what Mr. Justice Cawson said. Because Mr. Justice Cawson says plus or minus.
Well,
Could.
what?
Could, maybe as low as plus or minus 5%, could be as plus or minus 15%, or even higher.
Well, that's the range either side of the value. But what the court is required to do is determine what that range is, what the upper and lower limits of that range are. And the way the judge has expressed it is that 10% either side of that value could be entirely appropriate, in just the same way as 15% either side of the correct value should be appropriate. Now, given the conclusion that the judge reached on valuation, his conclusion that it is within the bracket, he must be saying there that it is 15%. But he has accepted that 10% is entirely appropriate in the circumstances of this case. And if that is what the judge has accepted, the only logical product of that reasoning could be that the correct range must be set midway between the two. It can't be right that the range is 20% and that the range is 30%, which is what the judge is saying there. So it must be, the judge's decision based on his reasoning must be that it is midway between the two. But we go further. We say that on the evidence, the judge could only have come to a conclusion, applying Mr. Justice Cawson, that it was 10%.
Right. Well, I mean, I think that's pretty clear.
Moving on, as I think I must because of time,
Yes.
to ground 3. Now, again here, I accept that this is an appeal against the judge's decision on a question of fact or valuation. In relation to the first aspect of this ground, the question is whether, in performing the comparison exercise between Bloxham Road and the subject property, any deduction should be made for what are described as enhancements. And we say there the judge misunderstood the evidence that he was relying on. And in relation to the second aspect of this ground, the judge simply failed to deal with the point that was before him about preliminaries, overheads and profits. Now, the context of this issue is the judge's analysis of the evidence of comparable transactions. And as I've said, the judge, like the respondent, based his analysis on one single transaction, the Bloxham Road sale. My final ground of appeal addresses that aspect of the decision, but for now I'm just focusing on what the judge did with that one comparable. And this was the process of adjusting the price of £13 million paid for Bloxham Road by grossing that up as it's described to reflect also additional costs which the purchaser of Bloxham Road would have taken into account in arriving at the purchase price, and then netting down the result of that with equivalent costs for the subject site. So unpacking that £13 million price for Bloxham Road and applying it to the subject site. Now, at trial, the appellant took issue with much of that process, but the judge largely accepted the evidence on behalf of the respondent that that's how the valuation should be done. We can see that process in paragraph 28 of the judge's judgment. So just to canter through that, what the judge did, accepting the respondent's evidence as to the appropriate way of comparing, was to derive for the Bloxham Road site a value for each market market plot being distinguished from plots that had to be given over to affordable housing, which were dealt with differently. So in stage one, the judge says that Mr. Jones arrived at a headline figure for Bloxham Road, and the headline figure derived from the price of £13 million. And then at the top of page 76, that was adjusted in the case of Bloxham Road to reflect the fact that deferment terms were agreed, where 3/4 of the purchase price was deferred for 9 months. So Mr. Jones applied and the judge accepted that it was appropriate to apply a rate to produce an effective price on the valuation date. And to that he added the section 106 costs. They are costs required to be incurred by a developer by the local authority that are enshrined in a section 106 agreement of 1.68 million for Bloxham Road, and what are described as abnormal costs for Bloxham Road, £795,000, to get to a headline figure of 14.8 odd million. He then converted that in stage 2 into a figure per unit. To do that, he first of all hived off the affordable housing at a fixed value of £20,000 per unit, and there were 44 affordable housing units on the Bloxham Road site. So he took away 888,000 and divided the result of that by the number of market units, 101, to get a market unit price of 138,469. Then in number 3, he adjusted that to reflect the increase in prices between the valuation date for the subject site and the date of the Bloxham Road transaction, and that led to a reduction to 125,250. So that figure was then transposed from Bloxham Road to the subject site, where in number 4 there were 50 market units permitted by the planning permission and 32 affordable housing units, and he got to a gross price of 6,902,500. Then in number 5 there was what's described elsewhere in the judgment as the netting down process. He deducted the section 106 costs for the site and the abnormal costs for the site to arrive at a market figure, and for Mr. Jones that came to 4.075 million. Now, what this ground of appeal addresses is the netting down in respect of the number 1,870,502. And within that number, there were what are described as abnormal costs and building enhancement costs. Abnormal costs are, and there's no dispute about this at trial, are costs that are specific to the site, which are incurred to get the site ready for development. So things like building roads, drainage, landscaping and such like. Those costs will always vary from site to site, depending on location, topography and such like. Building enhancements comprise expenditure on the houses that are being built, which, as the name suggests, go beyond a basic specification. And the reason that this distinction arose in this case was that the relevant figures for the subject site were taken by the defendant from the reports of somebody called Mr. Pillinger, who was a quantity surveyor appointed in the expert determination process to advise on the likely build costs for the purposes of Mr. Jones's residual valuation. And Mr. Pillinger produced 2 reports for Mr. Jones. And in those reports, he worked from a Scott schedule that had been produced by Banner Homes, the buyer or developer, which listed the costs which Banner Homes stated it was intending to incur. And in his second report, Mr. Pillinger produced a schedule of all of the costs that would be incurred, all of the build costs, and they separated out abnormal costs and building enhancement costs. And one thing the parties did agree on in this case was the division within that schedule of abnormals as against enhancements. Now, I'm not going to take your lordships to the relevant part of Mr. Pillinger's report because the page is almost illegible because of its size. But what we do have is a summary in a supplemental report of Mr. Buckingham behind tab 20 in the supplemental bundle at page 238. And that summary identifies abnormal costs, is the top half of the page, of 730 odd £1,000, which when you add contractors' preliminaries, overheads and profits at 12% comes to £818,000, and then enhancements of 939, to which you add 112, which comes to £1,052,000 odd, totaling the 1.87 million figure that is in paragraph 28.5 of the judge's judgment. Now, in the comparable valuation, the issue was how these costs should be reflected in the netting down exercise. Now, what Mr. Jones did was he relied on information that was given to him about the Bloxham Road transaction by Savills, the selling agents.
Oh dear. Got to turn my phone off. Sorry about that.
Oh, we've got to 10 to 1, my lord.
Mm-hmm.
What we know from the evidence is that according to Savills, the price paid by the buyer for Bloxham Road accounted for abnormal development costs of £795,000, and the source of that information is an email exchange that Mr. Jones appended to his determination at page 64 behind tab 7 in the supplemental bundle.
So, just to be clear, the exercise you're about to embark upon is not to say how these numbers at page 238 should have been accounted for in the comparable, because these relate to the subject side.
Indeed.
It's whether there were any equivalents to be taken into account in the comparable, isn't it?
Well, it's two things, and it was accepted by the judge to be two things. It's whether there was any equivalence, but also what is the nature of these costs. Are these costs that ought, in performing this comparison exercise, to be deducted? And it was the evidence on this side that on any reckoning they shouldn't, because these are costs that are incurred with a view to a return, whether that's...
This is, any enhancements are not to be reflected at all. Is that
Indeed.
right? So you challenge that as a...
Yes, that's right. And...
So that's a point of principle, not a point of detail.
Yes, we say it's the judge misunderstanding and misapplying the evidence based on the findings that he's made, which I'll show you in a moment.
So the proposition you say he got wrong was what?
In deducting any enhancements at all from the gross value that he had arrived at for the subject site.
But if that's correct, we don't need to look at the numbers. That's just a point of principle.
Well, it depends on, it turns on what evidence was before the judge.
Okay.
So the judge had this evidence from the defendant of what he was actually told by Savills, and it's accepted on all sides that the numbers on page 64 are abnormal costs, strictly so called.
Sorry, 64 of the
64 of the supplemental bundle.
That's the appendix to Mr. Jones.
That's right. It's the email from Savills. That's the source of his 797.
Sorry, there are two supplemental bundles. Is it sub 1 or sub 2?
Oh, no, I'm afraid I only have one. I imagine it's number 1 because it's close to the beginning.
Behind tab 7, isn't it?
Yes. Sorry, my lord, I didn't realise that somewhere there are two supplemental bundles floating around.
I seem to have two.
Oh, well,
There you go.
if your lordship has...
Maybe they're both the same.
It's in the first one anyway.
It's one with 27 tabs in.
Okay, maybe. I've got two. Yeah, right. Okay.
Well, if your lordship has a page 64 that has an
I do.
email with
I
John
do.
Reed at the top,
I do.
that's...
I do.
I think your lordship ought to have the right thing. So the evidence on this side from Mr. Fort and Mr. Davies, the experts for the claimant, was, as I've said, that because incurring these enhancement costs is a matter of developer choice with a view to increasing revenue, whether that is increased sale prices or accelerated sales, then it is wrong, they said, to net down these costs when comparing with another site. Now, Mr. Buckingham's evidence for the defendant differed from Mr. Jones on this issue. Mr. Jones's case was that because he was only told about abnormals for Bloxham Road, he could do nothing other than deduct everything he knew about for the subject site as he had been informed by Mr. Pillinger. That was Mr. Jones's evidence, but Mr. Buckingham's expert evidence disagreed with that. Mr. Buckingham accepted that it was wrong to deduct the sum of 1.8 million from the gross value of the subject site. But he advocated a more nuanced approach on the basis that it would reflect the unknown cost of enhancements at Bloxham Road. His evidence on this is in his report behind tab 17 at page 190 in the supplemental bundle. And it's paragraph 6.7.1. And in particular, 3 paragraphs up from the bottom, he said, Mr. Jones's included enhancements, as well as abnormals, in the netting down of the subject site price. This does distort the comparable analysis. And then he goes on to say, if both sites had the same enhancements per square foot, this could be corrected by simply taking out enhancements from the netting down process. However, having inspected both sites, it's my view that the enhancements at the subject property would be more expensive than Bloxham Road, but not to the extent calculated. And then, dropping down to the top of page 191, he says that, in my view, a reasonably competent surveyor would have made an adjustment of around 50% of the enhancement costs, but it could differ by a range of 25 to 75%. So, Mr. Buckingham's evidence was that what the valuer ought to do is assess, so far as he is able, what building enhancements would have been factored into the £13 million price at Bloxham Road. Although Mr. Jones wasn't told about any enhancements, he accepts that there would have been some, and therefore that, Mr. Buckingham says, justifies reducing the gross value of the subject site by 50% of the total value of the enhancements. Now, the judge broadly accepted that approach, and this is paragraph 219 in the judgment. Page 119. But in paragraph 219, the judge also accepted the reasoning of Mr. Fort and Mr. Davies. He said, 6 lines down, however, I consider that some provision was properly required either to reflect the fact that there might have been enhancements at Bloxham Road, or that the whole of the enhancement cost would not be recovered through an increase in purchase prices. And so he says, in light of that, that the appropriate course was to follow Mr. Buckingham's 50% deduction. Now, the argument on this ground is that the judge's conclusion that Mr. Buckingham's 50% figure should be applied on both counts simply doesn't work. And once it's accepted, as it was by the judge, that costs were incurred for the purpose of obtaining a specific return on those costs, whether that be with increased sale prices or an increased rate of sale, the rationale for applying Mr. Buckingham's 50% reduction falls away.
So are you saying Mr. Buckingham is wrong, or are you saying the judge is wrong in his application of Mr. Buckingham's principle?
Well, we say both, but we don't need to say that. We don't need to go so far as to say that Mr. Buckingham was wrong. The fact that the judge has accepted that they're not either or principles. It's not one or the other. But the fact that the judge has accepted Mr. Davies and Mr. Fort's analysis of how enhancements should be treated in the comparable valuation.
So where does he do that?
In the sentence I just read out, he says, however, I consider that some provision properly was required either to reflect the fact that there might have been enhancements at Bloxham Road, or that the whole of the enhancement cost would not be recovered through an increase in purchase prices. And so...
Is that different from what Mr. Buckingham
So
said?
it's 1 o'clock. How long have you got left?
I'm nearly finished with this ground, and then I have one more ground to cover. I would hope to be able to do both in 20 minutes.
Okay, 2 o'clock.
Why is it